Hello, Namaste. Welcome to our class today. So, welcome to our class today. So, today we are going to conduct a class regarding All India Bar Examination 19, and welcome to the YouTube channel Abhijna Legal Maps. And this is regarding All India Bar Examination 17th question paper which is being solved. So, let us begin with without any delay. Let us begin. Yes. See here, the first question, the section 12 of Hindu Maintenance and Adoption Act 1956 deals with. So, here we can see that what is section 12 of Hindu Maintenance Act, what does this deal with? Yes. So, it deals with the rights of adoptive parents to dispose of their properties, effects of adoption, presumption as to the document relating to adoption, or cancellation of adoption. So, here we can see the section 12, this deals with the effects of the adoption. So, when a person is adopted into one family, he will sever all ties with the earlier family, and the new ties are, he will get the rights whatever he would have got in the new family if he would have born there. Okay. So, B is the answer here. Next question, which of the following categories of cases will not be entertained as public interest litigation? See here we can find different types: family pension, petition from right victims, neglected children, or landlord tenant matter. In all these cases, see, these are our public rights, but regarding individual rights, public interest litigation is not entertained. Okay. So, D is the answer here. Next question, who is known as the father of public interest litigation in India? So, this is the most common question which has been asked in the All India Bar Examination. So, it is Justice P.N. Bhagavathi. He was the most proactive judge who entertained lots of public interest litigation and gave various theories on that. Okay. So, D is the answer here. Next one, which of the following is not a real purpose of public interest litigation? Vindication of the rule of law, facilitate effective access to justice, meaningful realization of fundamental rights, and getting famous and making wealth. See, we can see that being famous and making wealth, of course, it is not the object of any of the proceedings, judicial proceedings, right. So, D, this is the answer, that it is not a real purpose of public interest litigation. Next, in Husainara Khatun versus State of Bihar, what is this? Which right was recognized as a basic fundamental right? So, this was a very famous case regarding under trial prisoners. Okay. So, this upheld the right to speedy justice, because the prisoners, under trial prisoners, cannot be held in the prisons for any amount of time. They need to be, justice needs to be delivered quickly, right. So, that is why A is the answer here. Next one, which of the following writs can be issued against usurpation of public office? See, when it comes to the public office, with what authority do you hold this office? So, the question, when the question comes in that manner, then you would go to the High Court and obtain the writ of quo warranto, which means what authority do you have? Okay. So, C is the answer here. Next one, Ridge versus Baldwin's case deals with corporation, natural justice, state liability, and delegated legislation. So, what is the answer here? So, this is a very famous case relating to natural justice. So, B is the answer. Next one, meaning of audi alteram partem. See, this is audi alteram partem is the basic principle of natural justice. Okay. Natural justice. So, there are two rules, that is, the judge cannot be he cannot be biased, he cannot be judged in his own case, that is one rule, and this case is no one should be condemned unheard. So, this is the principle, because for that reason the show cause notice and hearing all are being done in a proceeding, so that to ensure natural justice. So, B is the answer here. Next one, rules made by Bar Council of India in exercising the rule making power under. See, Advocates Act 1961, C is the answer. So, this under section 49, this provides rules. Okay, this provides rules for it gives the power to the Bar Council of India to make rules regarding the professional ethics, and whatever conditions they have given, they can make rules. So, C is the answer here. Next one, which one of the following is not a ground of divorce in the Hindu Marriage Act? Mental disorder, venereal disease in communicable form, incurable unsound mind, living separately for less than 3 months. See, which is not the ground for divorce? See, all these could be grounds for divorce under different category, but see, living separately means it doesn't it's not proper, because either there had to be desertion for at least 2 years. Desertion should be at least for a period of 2 years, or as per section 13 of Hindu Marriage Act, or there should be what we can say, they should have obtained a judicial separation, decree of judicial separation, and this decree of judicial separation is not complied, or they have not cohabitated with themselves at least for a period of 1 year. Only then that could be a ground for divorce. Okay, so that's why D is the answer. This is not a ground of divorce in the Hindu Marriage Act. D is the answer here. Next one, Indian Christians can obtain divorce under which of the following enactments? So, for Christians, the rule is Indian Divorce Act of 1869. This law is applicable to them. Okay. Next question. If any advocate is aggrieved by an order of disciplinary committee of State Bar Council made under section 35 of the Advocate Act, or Advocate General of the state may prefer appeal to the Bar Council of India within. See here, what is happening is, disciplinary committee is there, disciplinary committee of State Bar Council. This has passed a particular order under section 35. So, if you are aggrieved with that particular order, you may appeal to whom? You may appeal to the higher authority, that is the Bar Council of India. You may appeal to Bar Council of India. So, within how many days you have to appeal? What is the appeal period? That is the question. It is it is 60 days. Within 60 days you have to appeal, okay, as per section 35. Next one, ABC Private Limited Company chooses to convert itself into a public company by altering its memorandum. See, whenever a public company is altering, it is changing its nature, it is converting itself from private company to public company, then memorandum of association has to change, articles of association has to change. So, in order to change this, you need to pass certain resolutions, but you do not require ordinary majority, you need a special majority for that. So, that is why you require special resolution. B is the answer here. Okay. Next one, doctrine of lifting off or piercing the corporate veil is associated with. What does this mean? So, labor law, company law, banking law, or service law. So, whenever there is a doctrine or lifting of corporate veil, it means that the company, it is related to company law. Okay, B is the answer. Whenever the company is there, it has a separate legal entity. It does not have any kind of what we can say, same existence as that of its members or directors. It is completely different. It has a separate legal entity. But whenever there is certain fraud occurring in the company, or some avoidance of taxation is being done, or shell companies are being made, in such cases what do? They will lift this corporate veil and they will see the actual persons behind this company. Okay, that principle is related to company law. Okay, B is the answer here. Next one, under which section of Environment Protection Act of 1986 an appeal to NGT lies? National Green Tribunal Act was passed in 2010, and in the same act we can see that this enactment has made several changes in various acts. Okay, Environment Act, Water Act, in various acts it has made certain changes. When this is the case, the Environment Act, what does it do? Certain adjudicating officers are there, central government is there. So, whenever they pass certain order, then the appeal lies to the National Green Tribunal. So, this has NGT Act has made certain amendments in Environment Act in section 5A. B is the answer. Okay, here you can see B is the answer. Which one of the following fundamental duties relates to environmental protection? So, environmental protection relates to B, Article 51 AG. Okay, B is the answer here. So, direct question. Next one, Mr. A, who was agreed by an order made by controller or an adjudicating officer, may prefer an appeal to Cyber Appellate Tribunal. So, this is a question under Information Technology Act of 2000. Okay. So, whenever a controller or adjudicating officer, he is passing certain order. So, whom can we appeal to? We can appeal to Cyber Appellate Tribunal. And again, if this order is passed, and to whom can we appeal? If Cyber Appellate Tribunal has made an order, whom can we appeal to? We can appeal to High Court. Okay, it could be only in High Court, and it should be within the period of 60 days. Section 62 speaks regarding this. The relevant section is section 62. Next one, Mr. X, a person who is intended by Mr. Y, an originator, to receive the electronic record under the IT Act, is known as. What does this mean? See, we have originator and the addressee. Okay. So, originator will send the message to the addressee. Message means our WhatsApp message, it could be electronic message or anything. Okay. So, the person to whom the originator intends to send the message is known as the addressee as per the Information Technology Act. It is section 2B. Section 2B is covered under this. Next one, the minimum number of members required for registration of a trade union. So, under the Trade Unions Act, there should be at least 7 members. Okay, 7 members have to be there in order to form a trade union. So, that is as per section 4 of Trade Unions Act. Okay, D is the answer. The text of the certified standing orders shall be prominently posted by the employer and in the language understood by the majority of his workmen. See, as per the industrial standing orders, every establishment or every company, they should publish their services, their rules of service, rules of employment and everything. Okay. So, in what language it should be published? It is known as certified standing orders. In what language should it be published? It should be published in English. One, it should be published in the English, and also where most of the workmen, they know particular language, in that language they must publish it. Okay. So, this is as per section 9 of Industrial Standing Order. B is the answer. Next question, an advocate may, while practicing, take up teaching of law in any educational institution which is affiliated to a university, so long as the hours during which he is so engaged in the teaching of law do not exceed hours in a day. See, we have Bar Council of India has made certain rules. So, advocates right to take up, there is one rule, right to take up law teaching rules. According to this, advocate who is a practicing advocate, he can also simultaneously take up teaching as a part-time job, and the teaching hours should not exceed 3 hours per day. B is the answer. Next one, in which of the following landmark cases the advocate was held guilty of professional misconduct as he had forged the court order? So, it was in the case of Pratap Narayan versus YP Raheja. So, if any advocate, he makes forgery of the court order, he is guilty of professional misconduct. Okay. A is the answer. Next one, suppose a road accident occurs, then being an advocate, what is the correct way of approaching the situation? So, in this case, whenever if any this happens, road accident is occurring, then they are going to file a FIR. Soon after an FIR is filed, a petition is being filed in the court, and after that, when a petition is filed, a summons to insurance company is issued to them. Okay. So, A is the answer. Next one, the principle of ubi jus ibi remedium. What does this mean? This is a question under torts. So, wherever there is right, there is remedy. Okay. So, it was recognized in which case? Winterbottom, Chapman, Ashby or Rylands. So, this was recognized in Ashby versus White. C is the answer. Next one, the Gloucester Grammar School case is a landmark case based on which of the following maxims? See, this is a case of torts where it says that, see, we have two principles, damnum sine injuria and injuria sine damnum. Damage sine injuria means damage without injury. Injuria sine damnum means injury without damage. See, always whenever you have to claim a compensation, there should be injury without a damage. Sorry, there should be a legal injury. It should be a legal injury. Whenever there is a legal injury, only then you can claim damage. Even when damage has occurred without injury, then you cannot claim the compensation. But whenever there is a legal injury, and if that could be without injury also, without damages also, then there you can claim compensation. But in this case, you cannot claim compensation. So, this case was based on this. See, suppose there is a education institution which you are running, and after some time again another person is establishing another education institution. Here you may have suffered losses, but that does not mean your legal right is injured, because this person has set up his education institution as per his own terms. It is not violating your legal injury. In such cases, you cannot claim compensation. There may be losses for your business, but there is no legal injury. So, this was the case relating to damnum sine injuria, that is Gloucester Grammar School case. Next one, National Consumer Disputes Redressal Commission under Consumer Protection Act shall have the jurisdiction to entertain complaints where the value of the goods or services paid. Here we have to understand the jurisdiction of different forums. The district forum or district commission, which we can say, it has the jurisdiction to receive complaints up to 1 crore. State forum has jurisdiction to receive complaints from exceeding 1 crore to 10 crore, and the National Commission has the power to entertain complaint exceeding 10 crore. So, here what is the case? The National Commission has jurisdiction to entertain complaints above 10 crores. So, B is the answer here. Next one, under section 41 of Consumer Protection Act of 2019, an appeal from the order of district commission lies to. See, always we know from district commission to state commission to national commission, the appeal lies. Okay. So, we also know the section, we also know the forums. So, what is the answer? It is state commission. From district commission, the appeal lies to the state commission. Next question, for an individual to be deemed to be resident in India in any previous year, one of the conditions is, so if a person is said to be resident, then he should have resided in India at least for a period of 182 days, okay, in the previous year. This is as per section 6 of Income Tax Act. If not, there are also other category, like within 4 years he should have resided for 365 days, and every year at least he should have resided for 60 days, or in the period of 7 years he should have resided. So, there are different criteria, but remember, in the previous year he should have resided at least for a period of 182 days. Next one, Mr. Kapoor purchased a residential house in January 2021 for 80 lakh. He sold the house in April 2022 for 94 lakh. In this case, gain of 14 lakh arising on account of the sale of the residential house will be charged to tax. We have different types of sources of income, okay, income from house property, income from salary, income from capital gains, or income from business, income from other sources. There are 5 different sources of income. So, whenever a capital asset is being sold and some profit is, you are gaining some profit, then what will happen? It is income from capital gains. A is the answer. Next one. A person who has ultimate control over the affairs of the factory under Factories Act 1948 is called as. So, in Factories Act, this is coming under labor laws. So, in Factories Act, the person who has the entire control over the factory affairs, he is said to be occupier as per section 2. Next one, if the factory employs more than 1000 workers. See, as per Factories Act, if they employ more than 250 workers, at least 250 workers should be there for establishing one canteen. And if there are more than 1000 workers, there should be a safety officer. Safety officer should be there. Okay, so A is the answer here. So this is as per section 40B of Factories Act. Next question. So this is the question. Let me tell you the example here. See, what happens is, a person, he is telling to another person that you publish some defamatory material against Mr. B, Mr. C. Okay. So he says that what if, suppose in future C is filing a case against B. If suppose C is filing a case against B, then he says that I will indemnify you, I will give you whatever loss has occurred to you in fighting that case. Okay, so that was stated, but what happens is, although he guarantees, he promises to indemnify as per section 224 for, or even the basic principles of the contract, what does it say? Unlawful consideration, unlawful object, they do not form a proper agreement at all. Okay. So, A cannot be made liable to pay indemnity, because that is the basic rule. A is not liable to B upon any indemnity. Okay. So, A is the answer here. Next one. A person whom the agent names to act for the principal in the business of agency under the express or implied authority to name is called. There are different types of agents: sub-agent, substituted agent. See, when a person, he is a principal, he has delegated his authority to his agent. This is a proper principal-agent relationship. When the agent sub-delegates the work to another person, that could be sub-agent. Okay. It could be, he is called as sub-agent. But here what is happening? Principal has appointed A as an agent, but he is not willing to work. He is suggesting some other person to be agent. Okay, he is suggesting some other person. So he wants A2 to work in the place of A. So he is substituting. He is not a sub-agent, he is said to be substituted agent. Okay, this we can find in section 194 of Indian Contract Act. Sub-agent, section 191 we can find. Okay, next one. Here this is a question regarding injunction. So, when injunction comes, it is a question related to specific relief act. So, where an injunction can only be granted by the decree made at the hearing and upon the merits of the suit. See, temporary injunction is an immediate relief, but whereas perpetual injunction, it is only given at the time of the decree and only after proper hearing and on the merits of the case it is granted. Okay, so it is said to be perpetual injunction as per section 37 of Specific Relief Act. Next one, according to section 5 of Specific Relief Act, a person entitled to the possession of specific immovable property may recover it in the manner provided by. Specific Relief Act provides for different kinds of reliefs, that is recovering possession of the property, specific performance of the contract, rescission of the contract, rectification of the instruments, cancellation of the instruments, declaration, and also these are specific reliefs. We also have preventive relief, which is injunctions. Okay, so here we are speaking about recovery of the possession. It could be of immovable property and it also could be of movable property. The question is, if immovable property has to be recovered, in what manner it has to be recovered? So, section 5 of specific relief act says that it has to be recovered in the manner provided under CPC. Okay. So, very clear answer. The answer is B. It has to be. Although this is a question under specific relief act, in specific relief act only they have stated that it has to be recovered in the manner provided under CPC. Next one, where the mortgagor delivers possession of the mortgage property. So, this is a question. If you see the option, you can understand that this could be the types of the mortgages. This could be relating to the types of the mortgages. So, when that is the case, here what is happening? He is giving the possession. In simple mortgage, possession is not being given. He is giving the possession and he is allowing him to retain the possession. The mortgagor who is borrowing money, he is giving the possession of the property and allowing this person to keep the property with himself till all mortgage money or interest, it could be recovered. So, what kind of mortgage is that? Such mortgage is said to be usufructuary mortgage. It is defined under section 58. Okay, section 58 is very important in TP Act because it gives several definitions of what is mortgage, mortgage money, mortgage deed, and it gives 6 types of mortgages. So, very important section. A probable question may come from this section. So, please note them. Okay, section 58 is the answer. Okay, this is a question regarding GST. So, here what has happened is, let me tell the gist of this question, because reading the entire question wouldn't sound good. So, the question is relating to GST interstate supply. Say a person has to register if his turnover crosses 20 lakh, right? But sometimes what happens, if he is dealing interstate, then also he may have to register in his, first of all he has to register in his state. Here we can see that he is dealing in Delhi, Punjab, Uttar Pradesh and Jammu and Kashmir. In 4 states he is dealing. So, in one state he is getting exempted supplies. Okay. So, no need to give the GST, but here in Delhi, Uttar Pradesh and Jammu and Kashmir, they are taxable. Some are taxable and some are exempted. So, what he has to do? He has to register in these 3 states where he needs to pay tax. Okay. So, that is the answer to this question. The question was, where all should he register? The question was, this was the question. So, he has to take registration in Delhi, Uttar Pradesh and Jammu Kashmir, because in Punjab it is already exempted. No need to pay tax for him in Punjab. Next one, the primary GST slabs for any regular taxpayers are presently pegged at. So, what is the different slabs? It is 0%, then 5%, 12%, 18% and 28%. C is the answer. 0%, 5%, 12%, 18% and 28%. Next one, which of the following is not a negotiable instrument? Section 13 of negotiable instrument clearly defines what is negotiable instrument and what is not. So, it has prescribed 3 negotiable instruments, that is promissory note, bill of exchange and billing receipt. So, which of the following is not a negotiable instrument? It is the check is also a negotiable instrument. Billing receipt is not a negotiable instrument. D is the answer as per section 13. Okay. So, this is a question regarding Land Acquisition Act, right to fair compensation and transparency in a Land Acquisition, Rehabilitation and Resettlement Act of 2013. So, as per this act, what does this mean? As per this act, they say that the act is applicable to, section 2 says that, okay, section 2 speaks regarding to whom all it is applicable. So, these are some of the purposes for which Land Acquisition Act is applicable. So, regarding naval, military, air force, water harvesting, project affected families, sports, healthcare, tourism, regarding all these cases Land Acquisition Act is applicable. So that's why D, 1, 2, 3 and 4 are applicable. Next one, specified person under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act. It means any person other than. So who is a specified person? So they prescribe certain persons as per section 46. They say that these persons are said to be persons other than appropriate government company or association or body of persons or individuals. Okay, so that's why D, all of these they come under this category. Next one, who shall be the Register of Trademarks for the purposes of Trademarks Act of 1999? Who is said to be Register of Trademarks? See, here we have a Controller General of Patents, Designs and Trademarks. He is said to be the designer of, he is said to be the Register of Trademarks. Which one of the following is not a type of intellectual property right? See, copyright is a IP, intellectual property, patent is an intellectual property, designs is an intellectual property, geographical indications would have been intellectual property, but not historical indications. So this is not a type of IPR. So D is the answer here. In which of the following cases was it decided that a contract with a minor is void? A very famous case, Mohari Bibi versus Dharmadas Ghosh. In this case, it was said to be contract with minor is void. Then which of the following with respect to declaratory decrees is correct? So declaratory decrees, suppose the legal right is there, someone is denying that legal right. So to ensure that you are having the legal right, you are obtaining a declaration from the court that you are entitled to such legal right. But court may grant it discretionarily or mandatorily. Okay. So section 34 relates to that, yes, and it is also discretionary. So both. D is the answer. So C is the answer here. C is the answer. Next one. By which of the following Amendment Act of 1985 was the anti-defection law added to the Constitution of India? So this is a very famous law, and 10th schedule was added because of this Amendment Act. It was added by way of 52nd Constitutional Amendment. B is the answer. In which one of the following cases did the Supreme Court decide that a constitutional amendment is a law within the meaning of Article 13(2)? So it was held that in Golaknath, it said that constitutional law is a law and you cannot amend such constitutional laws which are violating the fundamental rights, right? But later this was overruled in Keshwananda Bharati case. That is a different thing. But D is the answer. Golaknath versus State of Punjab. What is Uniform Civil Code? Uniform Civil Code in India, UCC. It is a directive principles of state policy where the government later can prescribe certain, it's a welfare state, right? It can make rules for the welfare of its citizens. So that's why all citizens will be having same law in the cases of inheritance, marriage, or in different cases we can understand they will be having a equal or similar law. Okay, that is said to be a uniform civil code. So this is a question. As per Article 16, no citizen shall on grounds only of religion, race, caste, sex. Okay, see here, what is the extra one? What is the extra grounds here they are asking? We have to see. So here the answer has already been given here. Okay, it has already taken this answer. See, we have 7 grounds in Article 16 and we have 5 grounds in Article 15. Article 15 does not have descent and residence. Okay, it has all other grounds: religion, race, caste, sex, place of birth, whereas Article 16 has all these grounds. So, on these grounds there cannot be any discrimination, that is the rule. Okay? Yes. Next one, the minimum number of judges who are to sit for the purpose of deciding any case. Okay, this is a question regarding, whenever there is a question regarding substantial question of law, then there has to be particular number of judges. So, how many number of judges have to sit to hear that reference? So, minimum there has to be 5 number of judges, okay, as per Article 141 and 143 also. Next one, according to Article 300A, so Article 300A ensures that it is a constitutional right. Earlier, right to property was a fundamental right which was removed by way of 44th Amendment. So, Article 300A is a right, constitutional right available to all persons. It is not only available to citizens, it is also available to non-citizens as well. So, that is why they have stated that it is available to all persons. A is the answer. Which of the following is not a law according to Article 13 of the Indian Constitution? So, this question was deleted in the exam. Okay. So, Article 13 it provides a long list like rule, bylaws, custom or usage. So, it was supposed to be all of this was said to be the answer, but they have given none of these. That is why it does not make sense, right. So, they have deleted this question. Which of the following schedule deals with the union list? Okay, see here, 7th schedule prescribes 3 lists, that is union list, state list and concurrent list. So, Parliament can make laws on union list, states can make laws on state list, and both Parliament and state can make laws on concurrent list. So, that is why Schedule 7 is the answer. The title of the Constitution of India. See, usually in all other acts we will be having the title, short title, text, commencement and all will be given in section 1. But Constitution, it is entirely different. It has been given in somewhere last article, that is Article 393. Okay, it provides that this Constitution is to be Constitution of India. So, that is the title of the short title of the Constitution. So, even this question was deleted, as this would lead to more and more confusion. Okay, this question was deleted, otherwise this would be Article 393. 393 was the proper answer. So, fundamental rights have been given in which part of the Constitution? They have been given in part 3 of the Constitution, whereas this was a directive principle of state policy was given in part 4. So, remember, fundamental rights have been given in part 3 of the Constitution. Provision of the right of defense, private defense is given under. So, this is a question of IPC, and IPC has been changed as BNS, right. So, the sections 96 to 106 have been given, and when it comes to this, it is section 34 to 44 of BNS, new sections. The consent is not a valid consent under section 90 of IPC. See here, what happens is, A is doing certain offence, that is why B is getting a right of private defense, this we know. But if A is not capable of doing the offence, who are such persons who are not capable of doing those offences? It could be person of unsound mind or a child. They even though they do certain act, they may not amount to offences, but the other person B, can he use right of private defense? Yes, he can use right of private defense. This is one rule. But what if sometimes, this is one case. The question was, if these persons who are supposed to give consent in certain cases, if a consent is given and injury is being done to them, In that cases, what will happen? It is not an offence. This comes under general defense, general exception. But if this consent is obtained under injury, fear of injury or misconception, or by a person of unsound mind or a child below 12 years, then what will happen? Then that consent is not a consent at all. Even if they obtain the consent and if they inflict injury on them, that is said to be offence. It does not come under general exception. Hence all of this. D is the answer. Next one, causing the death of a child in the mother's womb is not homicide. So the answer is explanation 3 to section 299. Okay, the same section has been given under section 100 of BNSS. Same explanation, but the section number has been changed. It has changed to section 100. Punishment for defamation under the Indian Penal Code is simple imprisonment for a term which may extend to 2 years, 3 years, 4 years or 5 years. So in the case of defamation, what is the punishment? The punishment is for a period of 2 years. This is under section 500 IPC punishment, but now in BNS the definition and punishment has been given under section 356 of BNS. Next one, assault or criminal force to a woman with intent to outrage her modesty. This comes under section 354 of IPC or 74 of BNS. So what kind of offence is this? This is a cognizable and non-bailable offence. Okay, police is having more powers than other. C is the answer. So for this you have to refer to first schedule of BNSS, Bharatiya Nagarika Suraksha Samhita, that you have to refer. A places men with firearms at the outlets of a building and Z tell that, okay, see here what has happened is, a person he is bound by, he says that if you leave this place I will shoot at you, I will fire at you. So how can he leave? He is surrounded by the guns. So this is kind of a wrongful restraintment, and if a person is barred from moving in any of the direction, that is said to be confinement. Okay, so wrongful confinement is one of the form of the wrongful restraint. So he has committed the offence of both wrongful confinement and wrongful restraint. Actually this is the definition given under wrongful confinement. So we can say section 340 IPC or section 127 BNS, and that they have given. Next one, plea bargaining. So plea bargaining is not applicable to whom? Plea bargaining is not applicable to offences above 7 years or when there is an offence against woman and child, the child below age of 14 years. So here B is the answer. So plea bargaining, now the chapter has been renamed as 23rd of BNSS. Under section 82 and 83, if the IPC, an offence is punishable if it is done by a child. See, sometimes what happens, if it is done by a child below 7 years, there is complete absolute immunity. If the offence is done by a child below from 7 to 12 years, that is 7 to 12 years age gap, age difference, and they know what they are knowing, okay, if they have attained sufficient maturity and understanding, then they are said to have committed an offence. That is why it is said to be qualified immunity. If they do not understand the maturity or understanding of what they are capable of doing, then they are immune. But if they understand what they are doing and still they continue to do that particular offence, then definitely that is an offence. So B is the answer here. So name 2 essential conditions of penal code, penal liability. So always there should be mens rea and actus reus. So mens rea means guilty mind. Actus reus means wrongful act to constitute a crime. So C is the answer here. Which sections deal with the processes to compel appearance under CRPC? See here, summons is issued to compel the appearance or to compel the production of the things also. summons, warrant, then proclamation. In the case of things, search warrant is issued. So, many processes are there. So, what is the section relating to that? It is section 61 to 90, and the sections are section 63 to 93 of BNSS. They relate to this. An offence for which a police officer may arrest a person without a warrant is known as non-cognizable offence, cognizable offence, bailable offence, and D, none of this. So, it is said to be cognizable offence. The police officer is having the power to arrest without warrant. So, B is the answer. In a summons trial case instituted on a complaint wherein the summons has been issued to the accused, the non-appearance or death of the complainant shall entail discharge of the accused, acquittal of the accused, either discharge or acquittal, or none of this. See, in a case where the complaint has been instituted and that is a summons case, there if the complainant is not appearing or he might have died, then what is the purpose of continuing the trial? Simply accused should suffer, right? So, the accused is given the benefit and he is acquitted if the complainant is not appearing. So, this was as per section 256 of CRPC, but later now as per BNSS section 279 BNSS, section 279 BNSS, 30 days time has to be given to the complainant, so that he, if possible, he has to appear and continue with the proceedings. If he does not do that, then it leads to the acquittal of the accused. B is the answer. The next question is, if FIR is not registered by the officer in charge of the police station or station house officer, then what is the option available to the complainant? So, complainant can go to the SP, or he can also file a complaint, private complaint. So, D, this is the answer. He can approach SP or magistrate by filing a private complaint. So, this is as per section 154 of CRPC and section 173 of BNSS. Any police officer making an investigation under section 160 of CRPC cannot require the attendance of a male at a place other than the place. Okay, see here what is happening. An examination. Police, what is he doing? He conducts investigation. During investigation, he will ask certain persons to come to the police station. But there are certain persons who cannot be called to the police station, but they have to be examined at their residence. So, they are, who are those? That is, a woman cannot be called to the police station. And as per CRPC, earlier as per CRPC, the male who are between the age of 15 to 65 years, they couldn't have been called, or aged persons couldn't have been called to the police station. So, now again BNSS has made changes. It has decreased the age 15 to 60 it has made, and persons with acute illness, even that criteria has been added. Okay. So, now these many persons cannot be called to the police station. So, now as our question was regarding CRPC, what should we answer? We have to answer this. C is the answer. If this question would have been asked under BNSS, it would have been 60. 60 would have been the correct answer. Okay. So, what are the relevant sections here? It is section 160 of CRPC and section 179 of BNSS. Next one, section 125. What does this mean? It is regarding maintenance proceedings. So, maintenance proceedings is not applicable only to a particular religion. It is applicable, it is secular, it is applicable to all religions. Okay, so that was held in Shah Bano Begum case, a very famous case, due to which there was another act which was Muslims Protection of Women on Divorce Act 1986 was enacted. So, C is the answer here. Who has the power to summary trial of a case? See, in CRPC there was a provision of metropolitan magistrate, but now we do not have metropolitan magistrate. Okay. So, as per 260 of CRPC, all these persons had the power to conduct a summary trial, but now we do not have that provision. Metropolitan magistrate is not there now. So apart from metropolitan magistrate, CJM and JMFC magistrate are having power now as per section 283 BNSS, because we are including both explanations so that it could be helpful to you while comparing the answers. Okay, so D is the answer. Which order of CPC deals with temporary injunction and interlocutory injunction? Very simple question. Order 39 deals with temporary injunctions. The next question is, here the problem is a person is dealing in different cities. Okay, so where can he, if any dealer resides somewhere, where should he file a case? Should he file a case where he resides, or should he file a case where the opponent resides, or where the cause of action has arisen? So that is the question. So here we have to refer to section 20 of CPC, where it says that whenever there has to be a suit has to be filed where cause of action has arisen, there you can file a suit, or where the defendant resides, or where defendant works for gain, or where he carries on profession, business. In such places he can file a case in those places. So here what is happening, agent is residing in Ahmedabad and business is in Delhi where cause of action has arisen. So that's why he can file a case in either Ahmedabad or Delhi. This is as per section 20 of Code of Civil Procedure. Next one, which of the following sections of CPC deals with the concept of res judicata? So res judicata is dealt under section 11, which prohibits the filing of a new suit, the continuation of a new suit, because already the same suit, the same issues have been heard and decided, and the same direct and substantial question of law has been, question of fact, the issue has been brought in the new suit. That's why they cannot proceed with the new suit. So this is the principle under section 11. Whereas section 10 speaks regarding stay of suit, where two suits are pending. It provides for the stay of the suits. Okay, see, this is a very difficult question as per my knowledge. This is based on illustration, CPC illustration, that too on execution proceeding. But we can see that here they have already given the provision, Order 21 Rule 18. So it means that this is a simple case regarding set off. But set off of what? Set off of decrees. Normal set off we can find in Order 8. But here this is set off of execution, or we can also call it as cross decree. Okay, so A is holding a decree against B and B is holding a decree against A. So this can be cancelled, right? If we are saying 5,000, if there is 3,000 against them, this can be cancelled and only for 2,000 execution can be done. This is set off of the cross decrees. But sometimes what happens, A, B, C, D, they have claims against B. Sorry, claims against X, and X has claims against C. So can this be adjusted? Because here it is a joint persons. Here it is only one person who is having claim. So can this be adjusted, or what is the question? So here, as per the illustration, they can. Okay, he can treat his joint decree as a cross decree. It can be treated. Okay, so A is the answer here. Next one, A, B and C are co-partners of joint Hindu family. They jointly execute a mortgage in favor of Y. Okay, this is a question regarding setting aside ex parte decree. Okay, so whenever Order 9 Rule 13 of CPC, the question is regarding this. So whenever there is an ex parte decree, that can be set aside by the ex parte defendant by saying that he did not receive the summons, or he can say that sufficient cause was there for him not attending the court. But sometimes what happens, out of so many defendants, few would have appeared and few would have not appeared. So these two persons can set aside the ex parte decree. But when they have to set aside ex parte decree, it could be against the whole persons. Although C and D would have appeared, but decree has to be set aside because it could be related to them. It's a joint in nature, right? So Here this is purely a question of CPC Order 9 Rule 13. On that they have asked this, the decree can be set aside against all the 3 persons A, B and C. Here what had happened, one defendant had appeared but some had not appeared, but one defendant he asked for ex parte decree to be set aside. So although A and B had appeared also, it needs to be set aside because all these 3 persons are involved, they are having joint rights. Okay, so there is an affidavit. If a person is lying in the affidavit, what is the next course of action which can be taken? So the advocate can go for the perjury application. He can file perjury application, or under section 193 IPC giving false evidence, and similarly in CRPC for such giving false evidence summary proceedings will be taken under section 340. So A is the answer here. This is a question regarding proclamation. It comes under section 82 of CRPC or section 84 of BNSS. So it says that whenever a proclamation is published, in what manner it is published. So here they say where the person had lastly resided, it has to be publicly read in that place, in that town, or and it's not or, it's and, all these things have to be complied, and it has to be pasted or affixed in that place, in that house where he had resided, lastly resided, and it has to be pasted in the courthouse, in the notice board of the court, and it has to be published in the daily circulating newspaper. So all these 4 conditions have to be met when a person is absconding, so that he gets sufficient notice that okay, against me some proclamation has been issued, right? So D, all 1, 2, 3, 4 are correct. D is the answer. Next one, which of the following statements is incorrect? So first appeal can be on a question of fact or law or both. Second appeal can be on a substantial question of law only. Second appeal can be on a question of fact or law or both, or first appeal may or may not be in the High Court. Second appeal has to be in the High Court. So here what has happened means, see, first appeal is there, second appeal is there. So first appeal can be filed in any cases, but when second appeal has to be filed, there has to be only substantial question of law. Okay, it cannot be on fact. Second appeal can be filed only in the High Court, and only when there is a substantial question of law is involving, in that cases it will be there. So these 2 are the essential conditions which have to be met. So that's why this is the correct statement. This is also correct statement. First appeal can be with reference to question of fact or law or both, and this is also a true statement, but this is not a true statement. So that's why this is the answer here, as it is incorrect. C is the answer here. As per order 6, pleading shall mean. What do you mean by pleading? So order 6 rule 1 has given the definition as pleading could be either plaint or written statement. Okay, so C is the answer. Next one, which of the following orders deals with death, marriage and insolvency of the parties? So here we can see that order 22, this deals with order 22. So this deals with death or marriage. Death means when the suit gets abated. In all such cases it can be there. Okay, so C is the answer. The doctrine of res gestae has been discussed in which section of the Evidence Act? Section 5, 6, 10 or 11. Res gestae is something, the principle of evidence which speaks regarding, which form the part of the same transaction. Facts forming part of the same transaction can be relevant. Okay, they have been given under section 6 Indian Evidence Act or section 4 of Bharatiya Sakshi Adhiniyam. Next one, the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit. See, this is a very simple question. Indian Evidence Act, this question is based on the admission. Okay. So, see, A and B are dealing with, they are having certain dispute, but B's some case relates to C's liability. So, if C is admitting certain thing regarding this particular thing, then this admission is valid against these two parties, against B also, because the persons on whose liability depending upon this person's case is resting, even then his admission is valid against B also. It is not like only B has to admit, even upon whom the liability is there, even he is admitting also, even then we can say that admission is there. Okay. So, C is the answer, section 19 is the answer of Indian Evidence Act or section 17 of Bharatiya Sakshi Adhiniyam. Next one, judicial evidence. Judicial evidence means evidence received by courts in proof or disproof of facts, by police officer, by home department or by tribunal. See, judicial evidence always means it is the evidence in proof or disproof of the facts, right? So, A is the answer, in proof or disproof of the facts. Which of the following is not a document according to the Indian Evidence Act? So, all these are documents, an inscription, a map, a caricature. So, all these are said to be document. So, the question is which is not a document, then we can say none of this. Okay. The question is in negative form, that is why none of this is answer. Section 3 of Indian Evidence Act or section 2D of Bharatiya Sakshi Adhiniyam are the relevant provisions here. Next one, presumptions as to dowry death. So, Indian Evidence Act prescribes presumption under section 113B. It says that if a woman dies and if it is proved that the husband had subjected her to cruelty in demand of dowry, then it can be presumed that this is a case of dowry death. Okay. So, this is given under section 113B. Now, it is 118 of Bharatiya Sakshi Adhiniyam. Next question, the question is regarding secondary evidence. Which of the following is not secondary evidence? See, secondary evidence has been given in under section 63. There are 5 categories which they have mentioned, but now as per new Bharatiya Sakshi Adhiniyam under section 58, earlier 5 classification plus additional 3 categories have been added in the definition of secondary evidence. So, if we check them, the answer is which of the following is not secondary evidence. So, if we go for Indian Evidence Act, this is not secondary evidence. Copy is not certified under section 63. This is said to be not a secondary evidence. Which of the following provisions of CPC deals with the institution of suits? So, whenever you file a plaint, you can read that it says that plaint filed under section 26 of CPC. So, section 26 deals with the institution of the suits. C is the answer. So, defendant shall within 30 days from the date of service of summons on him present a written statement of his defense. Order 8. So, here what is happening? The defendant has to file written statement within 30 days. If not, if he cannot file it within 30 days, then he has to file within 90 days from the date of service of summons. So, this is the inner limit and this is the outer limit, but whatever it is, you have to file, the answer should be 30 days. Okay, this is a mandatory one. This is court may grant 90 days. So, that is why it is 30 days. and the provision is Order 8, Rule 1. Next one, the arbitral tribunal shall not be bound by in the determination of rules of procedure. See, arbitration tribunal is not a very strict body, which is unlike judicial institution. So that's why it is not bound to follow CPC or Indian Evidence Act. So this has been given under with section 19 of Arbitration and Conciliation Act. Which of the following sections deals with arbitration agreement in the Arbitration and Conciliation Act of 1996? Okay. So section 6, 7, 8 or 9. So if they provide sufficient cause, definitely they can provide 90 days. Okay, but answer should be in these competitive exams, the questions here, it should be 30 days only. The answer should be 30 days only. Of course, more than 90 days also they will provide if they provide sufficient cause. But answer, this is the proper answer, 30 days, because this is mandatory. Okay, the arbitration agreement, it could be either in the form of the clause or it could be in the form of an agreement also. So, which section deals with it? It is section 7. B is the answer. The next question is, under what circumstances arbitral proceedings can be terminated? The answer is relating to section 32. The section relating to this question is section 32, which speaks regarding termination of the proceedings. So, arbitral award terminates on passing final arbitral award, or the arbitral tribunal itself when it issues order for the termination. So, in these two cases, arbitral tribunal proceedings are terminated. So, we can say that 1 and 3, this is the answer, A is the answer. Under section 29 of Arbitration and Conciliation Act, in arbitral proceedings with more than one arbitrator, how is the decision taken? So, usually the decision is taken by the majority of the members, right, in the absence of the agreement. So, that has been provided under section 29 as given here. Next question, the provision for maintenance pendent allied. So, this is given under section 24. Permanent alimony has been given under section 25. So, this provides for the expenses during proceedings occur to the party. That could be either husband or wife. That is a unique nature in Hindu Marriage Act. In other religions act, it's only the wife who can get the maintenance. But here it could be the husband also. Even husband can get the maintenance if he is not able to maintain himself. Okay. So, here section 24 provides regarding maintenance pendent allied. Next question, a Muslim wife may sue for divorce under Dissolution of Muslim Marriage Act. So, this act provides for various grounds which are available to Muslim women to take divorce. So, one such condition is if a person goes insane, if her husband goes insane, at least for how many years? If he goes insane for at least for a period of 2 years. Okay, this is as per section 2(6), sixth ground. Then she can, that's a ground for divorce. That's a ground for divorce for a Muslim woman. Okay, 2B is the answer. Okay, this is a question where there is an act, Muslim Women Protection of Rights on Divorce Act. According to this, according to section 5, what is happening is, if they want to opt, because in Muslim law, the maintenance can be given up to iddat period, not beyond that. But certain provisions have been made under this act where they say that maintenance also given after iddat period also. But section 125 is very clear, it provides maintenance to women till she remarries. Okay. So, that is why this act, Muslim Women Protection of Rights on Divorce Act, it prescribes that if the woman wants to obtain relief under CRPC 125, then husband and wife both have to, together they have to file an affidavit saying that they are opting for maintenance proceedings under this act, not under this act. So, if they submit the affidavit, then it would be sufficient. They can make 125 applicable to Muslim divorced woman also. So that is given under section 5. A is the answer. Then which is not the ground for void marriage under section 11? We know section 5 prescribes 5 conditions for essential of a marriage. One is there shouldn't be bigamy, there shouldn't be subinda relationship, there shouldn't be prohibited degree of relationship, or see these three, for these three conditions, if it is violated, the marriage becomes void. So this has been given under section 11. The next condition, second condition was that if they are suffering from unsoundness of mind, then the marriage may become voidable. It may be voidable at the option of the party. Then the third condition is there could be either the bride should be not below 18 years. The bridegroom should not be below 21 years. So this is the age limit, and even if they violate it, the marriage is still valid. It doesn't become void or voidable, but it is a punishable offense. If they marry below the age of that year, it becomes punishable offense. So which is not a ground for void marriage? Child marriage is not a ground for void marriage. D is the answer here. So what do you mean by subinda relationship? Subinda relationship is something where from a person it is calculated up to third generation from mother and up to fifth generation from father. Okay, that is said to be subinda relationship. Here this is as per Hindu Marriage Act. B is the answer here. Section 3F provides that particular definition. Next one, a leading question may be asked in. A leading question can be asked in cross-examination, re-examination, examiner-in-chief, or D, none of these. So 99 question, it's cross-examination. It is given under section 143 Indian Evidence Act or section 146 of Bharatiya Sakshi Adhiniyam. Leading question means the questions which suggest answers. So such questions cannot be asked in re-examination or examination-in-chief, but it can be asked in cross-examination. Okay. The last question, extrajudicial confession means. What do you mean by extrajudicial confession? Extrajudicial confession means those confessions which are made before police or other persons who are other than judges and magistrate. If it is the confession is made before the judges and magistrate, it is said to be judicial confession. But if it is made to other persons other than judicial magistrate or judges, then it is said to be extrajudicial confession. It does not have much value. The confessions before the magistrate has much evidentiary value. That is the rule here. Okay. So this was all about our today's class, what we can say. So I would also want to say that we have a course, okay, that is All India Bar Examination 5 mock tests are available. So you can download Abhijna Law Series app. There you can find this 5 mock test for AIBE, okay, or you can directly go to abhijnalegal.in. There also you can log in and you can get the mock tests just for ₹267. Okay, you can find this mock test. We have provided in the content section, you can see 5 mock tests are there, then SAM PDF solutions are there. Okay, so you can also check them. So it's only available at ₹267. So once you log in, then automatically once you purchase, automatically you will be added to the test. Then you can log in through any of the platforms, through website or mobile. You can log in and you can get it. We also have other different books in different categories are there. You can check them. Basically we had Kannada courses so far, but now we are also upgrading ourselves to English lectures, and we have also launched another article website, okay, website related to articles, that is abhijnalawseries.in. The description we are giving in our YouTube description, the link we are providing there. So do find them. You can find different articles where basically charts. Basically we are providing the answers, providing some articles content to containing different charts. So that is the unique feature of our new websites. So it's at a very nascent stage, still we have to upgrade, but those who are searching some of the study material, they can find them in this website. Okay, so whatever doubts you have, you can contact at the number which has been appearing in the screen here. So thank you for watching. Very soon we are going to upload a new video regarding another All India Bar Examination 16th question paper we are solving, and also we are also solving some of the list of other important acts, minor acts, amendments, appeals, illustrations. Regarding all these things also we are making last minute revision. So do follow the channel. If you haven't subscribed, subscribe them. We also have Abhijna Law Series WhatsApp channel. You can subscribe to that, you can follow that, so that you get regular notifications. Okay, yes, thank you Tushar, thank you for your compliments, for your good words. So see you in my next video. Take care, bye bye.